廣東話，廣東話。好，廣東話得唔緊要，而家再試廣東話，廣東話，廣東話，廣東話，廣東話，廣東話，廣東話，廣東話，普通話都有，係，哦，廣東話，廣東話，廣東話，廣東話，廣東話，廣東話，唔係。
我哋喺呢度試啊！你會唔會呢個 house 掟咗俾佢，佢直接我覺得會係咯，所以一定要叫佢哋。係，我都係叫佢試啊！試嚟先啊！得，嚟。
而家有啦，應該我 out 咗啱啱。廣東話有，英文有冇
English channel, English channel, English channel, English channel, Legal Week 2021, Legal Week 2021, 1, 2, 3, 1, 2, 3, English channel, 1, 2, 3, okay?
keep 英文 keep 住英文講啊。
English channel, English channel. This is the English channel, 1, 2, 3, 1, 2, 3. 1, 2, 3, 1, 2, 3. English channel, Legal Week 2021. Testing. This is the English channel. English channel, 1, 2, 3, 1, 2, 3. English channel. 1, 2, 3, 1, 2, 3. Testing. Testing, English channel, 1, 2, 3, 1, 2, 3. This is the English channel, 1, 2, 3, 1, 2, 3, 1, 2, 3, 4, 5. Legal Week 2021, English channel. 1, 2, 3, 1, 2, 3, testing. This is the English channel. Is it coming through? English channel. 1, 2, 3, 1, 2, 3, 1, 2, 3.
Sorry，SI 同事，再嚟多一次廣東話先，因為要其他台都要試，唔該。
English channel, testing. 1, 2, 3, 1, 2, 3. Legal Week 2021. Testing. This is the English channel. 1, 2, 3, 1, 2, 3. Testing. 1, 2, 3, 1, 2, 3. Legal Week 2021. Testing. 1, 2, 3, 1, 2, 3.
Good morning. The Rule of Law Signature Engagement Event, SEE, a journey of transformation for a sustainable future will soon commence. Please be seated and mute your phones and electronic devices. For those who are attending the event online, please mute your microphones. Please note that simultaneous interpretation services will be provided in Cantonese, 普通话, and English with the headsets available at the help desk at the entrance. For those of you who are joining us online, you may choose the preferred language by clicking the language button on the sidebar. For any inquiries, please type your message in the chat box and we will assist accordingly. We have also prepared an evaluation form. For participants here at the HKCEC, the form may be accessed through the QR code displayed on your table. Online participants are also invited to fill out the online evaluation form. For media who are present at the venue, please proceed to the media zone outside the venue after the conference for any media questions. Thank you. The Honorable Ms. Teresa Jang, the Honorable Chief Justice Andrew Jang, distinguished judges, eminent experts and speakers, ladies and gentlemen, welcome to the Rule of Law Signature Engagement Event SEE, a journey of transformation for a sustainable future, organized by the Department of Justice of the Hong Kong SAR of the People's Republic of China. My name is Elaine, your MC for today. A very warm welcome to everyone participating in today's conference. For the opening session, may I first invite the Honorable Ms. Teresa Jang Yokwa, GBM GBS SCJP, Secretary for Justice of Hong Kong, China, to deliver the welcome address. Ms. Jang, please.
Chief Justice, Professor Dr. Gua, distinguished guests, ladies and gentlemen. On behalf of the Department of Justice, I extend my warmest welcome to our distinguished guests and speakers, and to those joining today's event in person and with the aid of technology, overseas speakers and participants that are able to join us virtually from all over the world. Today, we are here to celebrate three matters: the inaugural Rule of Law Signature Engagement event, the launch of the Rule of Law database, and the addition of Law Asia to the Hong Kong Legal Hub. The inaugural Rule of Law Signature Engagement event marks the last event of the Hong Kong Legal Week 2021, being complementary to the Rule of Law Congress, with the events being held in alternating years during the Hong Kong Legal Week each year. This event aims to have a more in-depth discussion on selected topics involving specific stakeholders. The event titled Signature Engagement Event, with the acronym SEE, is deliberately designed to tie in with the department's Vision 2030 for Rule of Law initiative for us to see and focus on important topics for discussion and advancing the vision for Vision 2030 for Rule of Law towards a sustainable future for all. The theme of today's event is a journey of transformation for a sustainable future. Through today's discussions, covering a number of crucial topics, including the development of legal technology, advancing access to justice, and importance of objective data, and how culture, legal traditions, and socio-economic factors interplay for the development of the rule of law, we invite you to join us in our journey and hope to enlighten your thoughts to share our vision in building and maintaining more equal and inclusive societies for a sustainable future in the region and beyond. Vision 2030 was inspired by and aligns with the United Nations 2030 Agenda for Sustainable Development. And in Goal 16 of the agenda, it aims to promote peaceful and inclusive societies for sustainable development, provide access to justice for all, and build effective, accountable, and inclusive institutions at all levels. The rule of law is a key pillar to the implementation of the 2030 Agenda and is identified by the United Nations Secretary General Antonio Guterres during the high-level political forum on sustainable development in July 2021. Invest in more equal and inclusive societies is one of the 4 areas requiring decisive action. In his speech at the general debate of the 75th session of the UN General Assembly last year, President Xi Jinping pledged for the establishment of the International Research Center of Big Data for Sustainable Development Goals, the first international scientific research institute in the world that serves the UN 2030 agenda through big data. Accordingly, the research center, operated by the Chinese Academy of Sciences, was inaugurated at the International Forum on Big Data for Sustainable Development Goals in September this year. In his congratulatory letter at the inauguration ceremony, President Xi stressed the importance of using technology and big data in helping the international community to overcome difficulties and implement the UN 2030 agenda globally, and to contribute to building a community with sustainable future, especially after the huge impact of COVID-19. We are very honored to have the Director General of the Research Center, Professor Dr. Guo Huadong, deliver today's keynote speech on the topic, Big Earth Data in Facilitating of Sustainable Development Goals, taking us through the challenges and constraints in the implementation of the Sustainable Development Goals and how big data solutions can improve, monitor, and evaluate these goals. The rule of law manifests itself in a multitude of facets, and I said in the ceremonial opening of legal year 2020 that there are many intimations of what constitutes the rule of law. Some may be described as perpetual truths and inspirational, whilst others imaginative or even misleading. There are many ways by which the practice of rule of law is to be assessed, some based on subjective perception, while others on objective data. Subjective data, such as perception-based surveys, may not accurately provide a fair picture of the practice of rule of law in a particular place. As such, in order to develop a mechanism to review the practice of the rule of law, it may be more productive to use empirical and objective data to review the practice of some core fundamentals in the practice of the rule of law. The United Nations noted that follow-up and review of the implementation of 2030 Agenda for Sustainable Development shall be guided by, among other things, data, and I quote, based on evidence informed by country-led evaluations and data which is high quality, timely, reliable, and disaggregated by income, sex, age, race, ethnicity, migration status, disability, and geographic location, and other characteristics relevant in national contexts. With the invaluable advice and guidance from the members of the Task Force of Vision 2030 for Rule of Law, and in line with the UN 2030 Agenda, we have embarked on a journey to study the use of objective data in reviewing the practice of the rule of law, as well as acknowledging the influence of culture, legal traditions, socio-economic conditions that may impact on the practice of the rule of law in different jurisdictions. I am delighted to share with you the good news that we have taken the first step forward to launch the Rule of Law database, which aims to provide an objective assessment of the practice of the rule of law in Hong Kong. Its features can be summarized into three aspects: the collection of objective data from open source. The objective data used in the database are collected from the public domain. However, raw data needs to be properly processed, analyzed, interpreted, and formatted before meaningful conclusions can be drawn. One must therefore avoid simply referring to the raw data as a direct reference to the practice of the rule of law in Hong Kong. Without proper analysis and interpretation, they may obfuscate as opposed to illuminate. Second, methodologies subject to refinement. In order to assess the practice of the rule of law in an impartial and fair manner, methodologies have to be developed and continuously refined to effectively analyze the collected data. These methodologies will enable us to review the practice of the rule of law fairly. In updating and further refining these methodologies, any informed and objective views are most welcome. Third, self-monitoring and striving for improvement. At this stage, all the objective data collected and analyzed are intended to enable one to review the practice of rule of law in Hong Kong with a view to striving for continuous improvement. In the long run, with sufficient data, more focused and specialized analysis on the data based on a methodology with appropriate weighting or such other mathematical formulae can be conducted to study the practice of rule of law in Hong Kong, thereby facilitating self-improvement. This is in line with target 16.3 of Goal 16 of the UN 2030 Agenda for Sustainable Development, and that is to promote the rule of law at the national and international levels and ensure equal access to justice for all. Further to the successful launch of the Vision 2030 initiative last year, the Department of Justice has spared no efforts in working on various projects to promote and advance the rule of law. For more effective promotion and capacity building, the 3 E's project, namely engagement, empowerment, and enrichment, have commenced and starting to take roots in the society. The Department of Justice also organized the International Youth Legal Exchange Conference 2021 in September this year as one of our enrichment projects to explore how culture and legal tradition may influence the practice of rule of law in different jurisdictions. Connecting the regional students and young legal practitioners in the Asia-Pacific region from 11 jurisdictions, views and ideas were exchanged on the cultural, socio-economic, and legal traditions of their respective jurisdictions and how those elements interplay with the development of rule of law. As a follow-up on the youth conference I've just mentioned, we have invited members of the adjudicating panel and the delegates awarded the best paper, University of Malaya, and the delegates awarded the best presentation, the National University of Singapore, for a more in-depth discussion of some of the cultural elements unique to their jurisdictions in the first roundtable dialogue section. We hope to provide more opportunities for the young generation to participate in international conferences, and subject to feedback from stakeholders, including all of you here, we may seek to include a youth-centric event in later editions of the Hong Kong Legal Week every year, in line with our aim of building a sustainable future for rule of law. Technological developments in the law and legal practice may impact on how law students should prepare for their future careers in this age of digital transformation. As lawyers, we are not experts in the field of science or technology, and this is where we bring in scientists and experts in these areas to collaborate and make use of the digital transformation to enhance the legal industry. Questions such as how judges can make use of technology in their courtrooms and how legal practitioners can make use of technology, such as online dispute resolution platforms in resolving cross-border disputes, will undoubtedly be asked, in particular against the backdrop of ensuring justice is not denied during the pandemic. Another intriguing question relates to the use of electronic means, such as e-discovery, to assist lawyers in achieving clarity, speed, and efficiency in managing voluminous documents, assisting in their fight for the best interests of clients. We will hear from the distinguished panelists on these issues in the panel discussion later this afternoon. The Department of Justice has long recognized the impact of legal technology, and to this end, the Inclusive Global Legal Innovation Platform on ODR, iGLIP on ODR, was set up to facilitate studies on ODR-related issues in collaboration with UNCITRAL, the United Nations Commission on International Trade Law, holding its first meeting in March this year and bringing together experts from all around the world to exchange views. Recently, the UNCITRAL Commission, at its 54th session in July, endorsed its Secretary's suggestion to continue to collaborate with Hong Kong on this area and to take part on iGLIP on ODR. The development of the Hong Kong Legal Cloud is also well underway, and with a view to providing safe, secure, and affordable data storage services for the local legal and dispute resolution sector to keep pace with the digital transformation. The third matter that calls for celebration today is the new addition of Law Asia to the legal hub. Building on the success of the 32nd Law Asia Conference in Hong Kong during the first Hong Kong Legal Week held in 2019, an agreement was reached between the Department of Justice and Law Asia in October this year to strengthen cooperation and exchange. This arrangement would allow Law Asia to expand their influence in Hong Kong and the region by having a presence in the Hong Kong legal hub, and the Department of Justice will assist to facilitate the organization, training, and conferences or other events of Law Asia that are of mutual interest to Hong Kong. Our arrangement with Law Asia is the first of its kind, and to continue to develop Hong Kong as an international legal and dispute resolution services hub, the Department of Justice will continue to explore the possibility of bringing other renowned international organizations to Hong Kong. Ladies and gentlemen, the UN 2030 agenda seeks to transform the world, and throughout the course of this week, I hope that you can see the Department of Justice is also committed to embark on this collective journey by engaging, empowering, and enriching our stakeholders, striving to achieve our ultimate aim of rule of law and justice for all. Thank you.
Thank you, Ms. Jang. Please be seated. And now, it is my pleasure to invite the Honorable Chief Justice Andrew Jang to deliver his opening address. Chief Justice, please.
Thanks, Chief of Justice, distinguished guests, ladies and gentlemen. I'm honored to be invited to deliver the opening address for the Rule of Law Signature Engagement event. The rule of law is often described as a cornerstone of our society and an indispensable key to the continued success of Hong Kong. However, different people may have different ideas about the rule of law. In this opening address, I would like to explore with you, from the perspective of the Hong Kong judiciary, some of the more often asked questions about the rule of law. That is, what is the rule of law? Why do we need the rule of law? What is the cost of the rule of law? Who and what makes the rule of law work? And what are the limits of the rule of law? What is the rule of law? The rule of law, while being a commonly invoked and discussed concept, is elusive in meaning because there's considerable room to debate what the rule of law actually means and how far the rule of law can go. In Lord Bingham of Cornell's seminal work, The Rule of Law, he said, "The concept of the rule of law is not fixed for all time. Some countries do not subscribe to it fully, and some subscribe only in name, if that. Even those who do subscribe to it find it difficult to apply all its precepts quite all the time. But in a world divided by differences of nationality, race, color, religion, and wealth, it is one of the greatest unifying factors, perhaps the greatest, the nearest we are likely to approach to a universal secular religion. It remains an ideal, but an ideal worth striving for, in the interests of good government and peace, at home and in the world at large. We must therefore remind ourselves that the term rule of law can bear a variety of different meanings, which ultimately hinge on, among other things, the different culture, traditions, history, and experiences of a particular jurisdiction. Moreover, a society's concept of the rule of law may evolve and change over time. As said by Lord Neuberger of Abbotsbury in a talk he gave in Hong Kong in 2017, what is taken for granted as part of the rule of law in one country today may well have been thought to be revolutionary or even ridiculous in the same country centuries or sometimes even decades earlier. Besides, there's also the difference between the thick and thin conceptions of the rule of law. The thin version of the rule of law has been described in these terms. The rule of law means literally what it says, the rule of the law. Taken in its broadest sense, this means that people should obey the law and be ruled by it. This version of the rule of law requires the state to be subject to the laws made publicly and administered openly by the courts, which apply the laws equally to all persons and authorities within the jurisdiction. Or, as Lord Neuberger put it, a society which subscribes to this version of the rule of law must be a society governed by laws which are properly enacted, clearly expressed, publicly accessible, generally observed, and genuinely enforceable. I pause to note that the laws we have in Hong Kong satisfied all these requirements. Notably, the thin rule of law does not require any specific content of the law and has been criticized for that reason. Thus, Lord Bingham roundly rejected the thin rule of law in favor of the thick version, which embraces the protection of human rights. This version of the rule of law has been described as follows. The rule of law can be defined as a system in which the laws are public knowledge, are clear in meaning, and apply equally to everyone. They enshrine and uphold the political and civil liberties that have gained status as universal human rights over the last half-century. In particular, anyone accused of a crime has the right to a fair, prompt hearing and is presumed innocent until proved guilty. The central institutions of the legal system, including courts, prosecutors, and police, are reasonably fair, competent, and efficient. Judges are impartial and independent, not subject to political influence or manipulation. Perhaps most important, the government is embedded in a comprehensive legal framework. Its officials accept that the law will be applied to their own conduct, and the government seeks to be law-abiding. This opening address is, of course, not the occasion to dwell on the merits and demerits of the two versions of the rule of law. Rather, it is useful to remember that a particular version of the rule of law, which functions well in one jurisdiction, may not necessarily be transplanted to another jurisdiction seamlessly and without any hiccup. It is a fact that there's no consensus as to how the rule of law should be defined and administered among jurisdictions, and due regard must be given to the unique circumstances and context of the particular jurisdiction concerned. In Hong Kong, fundamental human rights are constitutionally guaranteed and protected under Chapter 3 of the Basic Law and the Hong Kong Bill of Rights. The Bill of Rights is based on the International Covenant on Civil and Political Rights, which is constitutionally entrenched under Article 39 of the Basic Law. Moreover, although many of these rights are not absolute, the courts have consistently given them generous interpretations and jealously guard against any restrictions. So regardless of whether one subscribes to the thin or thick version of the rule of law, it can be confidently asserted that Hong Kong is a society which is governed by the rule of law. Why do we need the rule of law? There are many reasons why we need the rule of law, and I would mention just some obvious reasons. First, the rule of law affects us on a global scale. According to the United Nations, the rule of law is fundamental to international peace and security and political stability, to achieve economic and social progress and development, and to protect people's rights and fundamental freedoms. It is foundational to people's access to public services, curbing corruption, restraining the abuse of power, and to establishing the social contract between people and the state. Likewise, research by the World Justice Project shows that the rule of law correlates to higher economic growth, greater peace, less inequality, improved health outcomes, and more education across the globe. Secondly, the rule of law affects us domestically. The rule of law is the bedrock of justice because it ensures that everyone, whether an individual or a public body, is equal before the law and has equal access to justice. Under the thick version of the rule of law, it also upholds fundamental human rights. As a mature common law jurisdiction, Hong Kong has an established public law regime which ensures that the government and other public bodies operate within the law and that public powers are exercised in accordance with the relevant legal requirements. The courts also require that laws must be published and generally accessible, and the courts proceed on the general basis that laws should not be retrospective and they have to be certain. Thirdly, the rule of law is very much tied to Hong Kong's success as a leading financial hub of the world. Our impartial, independent, and transparent judicial system provides individuals and organizations with a secure business environment and a level playing field. They can be confident that whatever disputes that may come their way will be resolved in a fair manner by a court system that administers justice without fear of favor, bias, or deceit. In short, the maintenance of the rule of law is an essential safeguard to the continued success and prosperity of Hong Kong. What is the cost of the rule of law? The rule of law is not free, and in fact, it comes at a price. The insistence on the requirements of the rule of law, the strict adherence to procedural guarantees on fairness of the legal process, and the equal treatment of each and everyone who comes before the court are all achieved at a price. Legal proceedings take time, and sometimes fairly substantial time, to proceed and conclude, as much as the court wants to speed up the hearing of cases and appeals. The pursuit of efficiency cannot be at the expense of justice. Likewise, the holding of the government to legal accountability means that the implementation of government policies, decisions, or projects might be reversed or substantially delayed, no matter how important or desirable they may otherwise be for the public good. Members of our society must learn to understand and respect that the outcomes of judicial proceedings may not be to their liking or accord with where they consider justice lies. The decisions of the courts are based on legal principles, not on a quantitative measurement of overall social satisfaction. Indeed, a good way to measure how entrenched the rule of law is as a core value in society is to ask how well its institutions and members are able to respect unpopular judicial decisions and the judges who made them. Hong Kong prides itself as a society governed by the rule of law. The continued validity of this claim depends upon our community's willingness to pay the price that comes with upholding the rule of law. Who and what makes the rule of law work? The successful maintenance of the rule of law is supported by multiple pillars, and one foundational pillar is judicial independence. This is specifically provided for in various articles of the Basic Law. Article 2 of the Basic Law states, the National People's Congress authorizes the Hong Kong Special Administrative Region to exercise a high degree of autonomy and enjoy executive, legislative, and independent judicial power, including that of final adjudication, in accordance with the provisions of this law. Article 19.1 says, the Hong Kong Special Administrative Region shall be vested with independent judicial power, including that of final adjudication. Article 85 states that the courts of the Hong Kong Special Administrative Region shall exercise judicial power independently, free from any interference. Members of the judiciary shall be immune from legal action in the performance of their judicial functions. To give effect to these articles, we need judges who are independent, impartial, apolitical, fearless, and competent. And we need to have them in sufficient numbers. In Hong Kong, Article 92 of the Basic Law specifically provides that judges are to be chosen on the basis of their judicial and professional qualities. There can be no compromise on the qualities required. There should be no politicization of the appointment process. Equally important to note is that a prolonged inability to fill judicial vacancies may become a latent threat to the continued maintenance of the rule of law. The legal profession, and indeed our community, should actively encourage lawyers of the requisite qualities to apply to join the bench. Closely allied to judicial independence as an essential requirement for the rule of law is the public's confidence in the judiciary's independence. Without such public confidence, people may choose to resolve their disputes with each other or with the government by other means, and the rule of law may suffer as a result. It follows that unfounded doubts cast on the judiciary's independence or on individual judges' impartiality are damaging to public confidence in the judiciary and harmful to the rule of law. What are the limits of the rule of law? The rule of law, like all important doctrines or concepts, has its own limits. I would like to touch on only 2 points here. First, while some have suggested that the rule of law means the rule of good law, both in terms of the lawmaking process and the substance of the law, that is, the protection of fundamental rights, it has to be recognized that fundamental rights aside, even the thick rule of law does not dictate what the law's content should be. The making of good law is primarily the responsibility of the government and the legislature. In a common law jurisdiction like Hong Kong, where judges do from time to time make law on an incremental basis in suitable cases, that is also the responsibility of our judges, but only to that limited extent. It follows that the rule of law does not provide an answer to many issues, including social and political ones, that society faces. Over and over again, the courts have emphasized in public law cases that one must recognize the different constitutional roles played by the courts, the executive, and the legislature. It is not the function of the courts under our constitutional setup to interfere with, still less to rewrite, government policies and decisions, or to display laws enacted by the legislature, save where that is the necessary result of upholding the provisions of the Basic Law or other overriding legal requirements. It should be remembered that court decisions are based on the relevant legal principles and the facts of individual cases. It is the court's role to administer the law and decide legal issues. It is never their function to resolve any underlying political or social controversies. The courtroom is not the forum for the promotion or ventilation of political or other non-legal views. All this simply mirrors a broader and more general point. That is, the rule of law does not solve issues in society that belong to the province of the government or the legislature. In short, the essential importance of the rule of law to our society is beyond dispute. Nonetheless, it is not a panacea to all problems in society. In conclusion, once again, I thank the Department of Justice for inviting me to give the opening address for this very important event. It cannot be overemphasized that the continued success of Hong Kong is very much tied to the upholding of the rule of law. Let's work together and make sure that the rule of law will continue to flourish in Hong Kong. Thank you very much.
Thank you, Chief Justice Jang. Please be seated. And please join me in giving another round of applause to Ms. Jang and Chief Justice Jang for opening the event. And now, it is my honor to invite Professor Dr. Guo Huadong, Director General of International Research Center of Big Data for Sustainable Development Goals, CBAS, to deliver the keynote speech.
Ladies and gentlemen, I'm delighted to be able to participate in the Rule of Law signature event, a journey of transformation for a sustainable future. I'd like to speak to you about the Big Earth Data Science Engineering program. I'd like for you to view a video first. China is setting up the International Research Center of Big Data for SDGs in order to provide new support for the UN SDGs. Last year, in September 22nd, President Xi had announced the setup of the center, and I'd like to report to you about our work as of now. Now, first of all, we worked on the sustainability technology development. In 2015, 193 members of the UN had passed a very memorable document, which is in reform of our World 2030 Sustainable Development Agenda. It had introduced comprehensive targets that can ensure the sustainable development of the human society, economy, and world, and had laid out a roadmap. This is a very meaningful document. However, SDGs implementation faces huge challenge. Why is it? So regardless of the 17 or the 169 targets, we separate that into three types. One is there's a methodology and data, and the second one is methodology but no data. And the third one is that there are multi-tiers of classifications, meaning that almost half of that does not come with data, and that increases the challenge. The 2015 UN had a mechanism
for sustainable development technology, composing of 3 sectors. One is technology innovation. So this is an organization of the UN, a team, and also a pilot team.
Next is the Innovation Group, so that at the General Assembly, we're going to set that up. And we also noticed that the existing innovation platform can also be made use of. As for technology innovation that can promote the 21st century's development, and the target is to be assessed and there are different goals and there are different methodologies that can be applied. And with the data that are being collected, we believe that we have the global data, and therefore that can be made use of, and there are also new techniques that can be used, that can be made use of, that will be able to have large quantities of specific data. And how we're going to develop them, and the Chinese Institute of Scientific Development has adopted this approach in 2018, and that is we have set up this specific project on global big data. And we will also be building data collection database, so we will be having this academic exchange platform. And we are also going to set up an advanced system. And after 4 years of hard work, we have already built this cloud service. And also you can see the capacity. And we are talking about the supercomputing capability. And we have also used this analysis capability in order to set up this system. And we have also got this AI data bank system, so that we have our own data bank, and this data bank is equipped with data collection capability. For example, we have various systems that can collect and store a lot of data. And we would also be sharing such data, and therefore we have adopted this specific approach, so that when we use specific algorithms, we'll be able to analyze and share such data with other parties. And after a few years hard work, this platform has already met the requirement, and by this year, we have already got 10 TBs storage, and also some 40 years of data, and also different types of information have been collected. And such data will be able to play a very important role. 170 jurisdictions and over over 50 million browsers, and also the daily average is about 540,000. And we have got this big data platform, and that's under the SPG. You can also see how it works.
可持续发展大数据国际研究中心研制开发了先进的 SDG 大数据平台。平台利用大数据与人工智能技术，面向零饥饿、清洁饮水和卫生设施、可持续城市和社区、气候行动、水下生物、陆地生物等6个联合国2030年可持续发展目标，系统整合基础地理、遥感、地面监测、社会统计等多种数据，提供数据产品按需生产，指标在线计算，交互式分析与决策支持 ，SDG 专用数据存储等核心功能，提供一站式数据计算、分析、展示、共享
system so that we can share the data with other parties.
平台采用自主设计的
We have said that our platform has used the most advanced technology so that it will be able to do its own analysis, computation, storage, and also panoramic view and collection of data. And we are able to do supercomputing, and we're able to store big data. And the CPU's computing capability would be a lot higher than other similar devices. And through unified standards, we have been able to provide support to the researchers, and we are able to respond to specific requirements and requests. And as this system has been developed by ourselves, and it has been sent to different jurisdictions, and we've been able to conduct underwater studies and other studies, and we will also be able to carry out researches on request. And we're also able to conduct analysis on PP data, and with the data analysis engine, the team has also continued to develop the Python system, and we have also conducted further studies on SDG research, and we were also going to develop on each and every SDG goal, so that they can also be shared online. And we'll also be able to make sure that the data will be transparent, so that everybody will be able to view it. And SDG data and also the product utilization rate can also be combined, so that we'll be able to carry out our calculation online. And that's a very good demonstration of the capability of our system. And we will also be able to collect precise data, and that can also be processed real time, and we will be able to provide data about typhoons, hurricanes, and earthquakes, and so on. So that we will also be able to have aerial systems to monitor the situation. The platform has also built this storage, so that we'll be able to store up to 10 PB data, so that it can be accessible and it can also be duplicated, so that global users will be able to access the system, and will be able to disseminate the information instantly to all users. And the distribution is also very wide, and therefore it can be uniformly disseminated to users all over the world. And we can also consolidate the data and analyze that for the purpose of the United Nations in order to achieve the SDG, and we'll be able to provide further contribution to the 2030 SDG of the UN. As you can see here, this specific project has kicked off, and that will provide the basis for further development, and I'll be explaining how we'll be able to use it to support the SDGs development. Well, this year, if you look at our past 4 years' efforts, we have made use of such big data, and we have done a lot of analysis and assessment, and we have also submitted our thematic report, and 2019, 2020, 2021. The reports have been compiled on the basis of such systems, and Chinese experts have also taken part in such work, and we have also announced the 2 5-year plans, and then in 2020, China has also participated in this project, and we have also published a report, and this year, we have also announced the 2021, the Global Big Data Support Networks report, and in the report, I'd like to cite several examples to illustrate that to you. So we have assessed 20 goals, and out of those 20 goals, 4 goals are very close to the target set out for 2030, and those 4 goals are that is for 2020 to 2017 is about children's growth, and by 2024, for those under 5, retarded growth rate would be lowered from 18.8% to 4.8%. So you can also see that goal 11 is about 2020, that is for public transport utilization rate in China. Well, the overall rate was 90.19 when compared to 2018. It went up by 9.59%. So basically, we have been able to achieve our goal of enabling everybody to use public transport. And also for another goal, that is about the site formation rate in China, and that has gone up by some 60.3% when compared to 2015, and therefore we have made significant contribution to the use of land, and we've been able to complete and achieve the goal on schedule. And for the other goals, we have also conducted 6 other studies so that we'll be able to ensure that globally, well, we are in the midst of development, and you can see how well we have done. We are still encountering some problems in certain areas. And for 11.3, that's about the degradation of land resources, and we have announced the situation. Well, in China, if you use the agricultural land, that is the area that can be farmed, that has come down. And we have also worked with the UNEP and also the UCL to conduct a study. And in May this year, we published a report. It's about the environment and also SDG assessment. And we have worked with the UNEP. We have announced that to our country. And they've also come up with a report. It's about the emerging science and also the top-notch technology services report. As you can see, well, the UN has conducted this climatic change summit, and it's been held in Glasgow, and we have been asked to supply big data, and we have made our contribution to that conference. And we have told them that our main task is to take part in some main events of the UN, and for the Sustainable Development Goal, we'd like to make meaningful contribution to that. And summarizing what I've said just now, I'd like to show you another video clip so that we can look back on what we have done so far. Well, propagate, create, survival, develop, and meeting challenges and so on. On this blue planet, humankind has never ceased to move forward. Today, sustainable development has already become a global consensus. But then climatic change has resulted in a lot of natural disasters, and therefore there are a lot of variables in our world. The UN has introduced this 2030 Sustainable Development Goal to ensure that SDGs will become the core, and then we will also be working towards improving the entire humankind and the environment that we live in, and that's also to be translated into an action plan. And the UN has also got this promotion mechanism to promote innovation development in order to promote the development of our planet. And in the process of digitization, big data would also enable us to have a better understanding of the world, so that we will also be able to move ahead with global changes. And it's also an era where we have the mission of developing new renewable energy. And the Chinese Scientific Institute has also committed itself to this big data system. And through big data, we are able to disclose the impacts of various work on our globe. And we have used big data to provide scientific innovation for our world. The global big data project has been listed as an online platform under the UN, and the Chinese government.
For consecutive 2 years, the Chinese government has announced the sustainability targets report in the UN. 2020, China, in the 75th UN Congress, had announced the setting up of the International Research Center of Big Data for SDGs. And this is out of the very strong demands for SDG sustainability. And it is also a system whereby we can build a digital platform to provide scientific support for SDG efforts. The center has 5 missions, and in various frontier areas that has to do with SDG, we are starting to collect big data and also to conduct analysis and research for predictability, and also to use sustainability satellite technology innovation in order to build a sustainability database, and also to start sustainability training and education. We deeply understand that our pursuit for understanding of this blue planet had never stopped. In the future, our sustainability pursuit would still face huge challenges. So the lack of data would be a huge obstacle. So to build this big database support is a very challenging mission and a very important one. And however, we are confident that the future of human beings would be still more beautiful. And we are constantly creating breakthroughs to create a better future for human beings. Now, the big data is a unavoidable, a necessary drive for human development. Yes, let us also talk about the current circumstances of the International Research Center for Big Data for SDG. This June, the center was officially opened, and the chairman had congratulated us, saying that the setting up of this center is a very important task of his in the current development plan. And the UN Secretary General also congratulated us. He says,
"The new International Research Center of Big Data for the Sustainable Development Goals. The information you harness has enormous potential to help address climate change, advance the SDGs, and respond to the COVID-19 pandemic. This research center will work side by side with the regional hub for big data to support the UN Global Platform. Together, we can do more to end poverty, protect the planet, and promote peace. Big data is a powerful tool. Everyone using it has a solemn responsibility to ensure equitable access, individuals' privacy, ethics, security, and respect for human rights. Your new research center can build on the momentum that's being generated by the UN Technology Facilitation Mechanism for innovation, solutions, and better results where policy meets science. Together, we can mobilize scientific and technological communities to help achieve the Sustainable Development Goals. The United Nations remains committed to making the most of big data in the service of humanity, and I thank you.
The Secretary General, while congratulating us, his hope is that big data this big data platform could contribute to the achievement of the SDGs. This center in the future how, and what, how do we develop ourselves into the future, and the guideline that we would follow is very important. We adhere to the big data sustainability target to build our platform and our mechanism, and also work with United Nations institutions and its members to pursue this target. And our goal is to build a public big data technology platform and a research institute to continue to research into this area of science, and also to nurture talents who can make use of this data. We have 5 measures. One is to build the SDG big data platform, and also to operate the SDG scientific satellite, and also to conduct assessment and monitoring analysis, as well as other targets. And in the course of work, in order to ensure that our data is constantly updated, we have set up the world's first sustainability satellite. I'd like to report a good piece of good news for you, and which is this satellite in November 5th, meaning today, it is to be launched officially. This will benefit Hong Kong, benefit China, as well as the rest of the world. So I hope that the data collected by the satellite would be well used. And last but not least, I like to say that big data is a common resource for humanity, and it is also a target that humanity needs to pursue and work hard for. And this is the mechanism whereby we can join hands to ensure and to contribute to the achievement of the sustainabilities of goals of China, as well as of the UN. Thank you.
For the next session on the launch of the Rule of Law database, may I invite Dr. Thomas So, JP, to address the audience. Dr. So, please.
Secretary of Justice, ladies and gentlemen, good morning. Thank you for joining me today to witness the launch of the Rule of Law database today. And we are very happy because we have just heard from Professor Guo that today, the 5th of November, probably is the day that we're going to remember, not only because of the launch of our satellite, but also the launch of our Rule of Law database. And I'm very happy to be the person today to talk to you all about another type of data, following the big Earth data that Professor Guo has just taken us through, which is also relevant to the UN 2030 Agenda for Sustainable Development. But our database, the data that we talk about now, is more relevant to the development of the inclusive rule of law, to the development of an inclusive rule of law society. Before we go into details of the rule of law database, let's look at some background. Vision 2030 for rule of law is a visionary initiative which spans over 10 years. It was officially launched on the 2nd of November 2020 by the Department of Justice. The initiative seeks to promote the proper understanding and recognition of the rule of law by studying its various elements through research, stakeholders' collaboration, and capacity building, thereby contributing to the sustainable development of inclusive and fair societies at both the local and international levels. One of the important projects of Vision 2030 is the collection of objective data with a view to setting up a database, starting with Hong Kong, on information pertaining to the development and practice of the rule of law. Through these objective data, we can conduct research and having regard to the social and legal cultures of the region, we will be able to solidify the proper understanding of how rule of law is practiced and then to improve on it as necessary. With the guidance of the Task Force on Vision 2030 for rule of law, efforts have been made on collecting and collating the relevant objective data in Hong Kong, and a dedicated database, which is the rule of law database, has been set up. I will explain a bit more details about the ideology behind the rule of law database and the proposal to formulate an objective methodology for reviewing the practice of rule of law in the respective jurisdictions. Our experience on the data collation and analysis will then be shared with other jurisdictions. About the importance of the objective data in reviewing rule of law practice. Whilst the elements of rule of law are plentiful and generally recognized internationally, there exists no universal accepted system for its assessment. Often, the indicators chosen for assessing rule of law practice and the variety in the sources of the data, for example, perception-based sample size surveys and selective expert pools, differ across various international ranking reports on the rule of law. There has been contention that methodology based primarily on the perception of rule of law may not accurately reflect a fair observation of the actual situation of rule of law practice in the jurisdiction, as the same set of survey given to a different person may generate a totally different outcome materially affected by personal views and experience, educational background, political stance, etc. In contrast, objective data would probably provide empirical evidence reflecting the actual situation of rule of law practice in a jurisdiction, which enhance a fairer review of rule of law practice in an objective way. The idea of using objective data for reviewing rule of law practice is in accord with the United Nations 2030 Agenda for Sustainable Development, which stresses on the importance of objective data and statistics for sustainable development. In the long run, based on the data collected, in-depth and focused analysis of the use of this data to formulate an objective methodology for reviewing the practice of rule of law is expected to be conducted. It is hoped that Hong Kong's experience of setting up such database and the use of such methodology can be shared with other jurisdictions with a view to jointly promoting rule of law in alignment with the spirit of the 2030 Agenda. About data collection and collation, in the case of Hong Kong, there is a sheer volume of objective data pertaining to the practice of rule of law in the form of statistics, figures, and other form of information already made public by over 100 local entities as data sources. Having noted that such data are largely scattered and fragmented, efforts have been made to collect, collate, and analyze the data in order to develop the rule of law database. Remarkably, we propose to focus on the core data, we call it core data, which are indicative of the fundamental values of rule of law and are expected to be commonly available across jurisdictions. These core data will be able to, when taken into account in a holistic manner, review the basic fundamentals of the practice of rule of law in the respective jurisdictions. Certain data are transformed using dedicated mathematical formulae so as to be fairly interpreted. For example, if we look at the legal aid department's annual expenditure, we're going to have a table show on the slide there. These figures does not directly show how much financial allocation is accorded to the department by the government. Such data also cannot be compared across jurisdictions in view of the different national income and government resources. If the data is converted into the percentage of annual government expenditure spent, the resulting figures are capable of demonstrating the government's resources allocated to the legal aid, which may be capable of being compared with other jurisdictions' share of government expenditure spent on legal aid. Let us now look at how we use the objective data to review rule of law practice. In order to formulate a methodology to review the practice of rule of law using the objective data, it is necessary to firstly identify appropriate rule of law indicators. At the moment, we propose to broadly categorize the objective data into the following 7 indicators, which are considered fundamental principles of rule of law that may be generally agreed. Judicial independence, equality before the law and protection of the right to non-discrimination, accessibility of laws, efficacy of civil and criminal proceedings and dispute resolution system, prevention of corruption, prevention of abuse of government power, and fundamental human rights protection. For each of these rule of law indicators, in order to best reflect how the indicator is to be reviewed, the related data will be divided into 3 categories according to different features of the data, namely the infrastructure information, the resources data, and quality data. Under the category of infrastructure information, questions are devised to ask for the provision of objective information relevant to the individual indicator. The answers should be capable of revealing the basic fundamentals of the rule of law practice under such indicator. That is why the data is named infrastructure information. For instance, the following are sample questions relevant to studying the indicator judicial independence. For example, we ask ourselves, is there a legislative framework for the protection of judicial independence? For example, the courts, are there any provisions saying that the court shall exercise judicial power independently and free from any interference? Are judges chosen only on the basis of their judicial and professional qualities? Is there any political vetting process before the appointment of judges? Are judges appointed based on the recommendation of an independent body? Is it legally provided that judges shall be immune from legal actions in the performance of the judicial functions? Do judges have security of tenure in their office? Is there a specified process by which judges can be removed? Do judges set out the reasoning in their judgments? Are written judgments available to the public? Questions like this are all very relevant to our study on this indicator, judicial independence. More examples of questions for other indicators are available in the rule of law database, which I would invite you all to click into our link, which will be made public at the end of this session. About resources data, under each indicator there may be objective data regarding the proportion of the government's pecuniary input on the relevant aspects. The example concerning the annual government expenditure on the legal aid department in Hong Kong just now, we discussed earlier, such data is relevant to the extent to which the residents' right of access to the court is safeguarded in Hong Kong. The percentage of expenditure can provide a fairer overview of the governmental weighting anchored to legal aid, given that different countries have different sizes of government expenditure, both in per capita terms and as share of GDP. The trend of the data can be used for vertical comparison within the jurisdiction so as to facilitate the policy making for improving the situation, and such figure can be compared horizontally across jurisdictions. The relevant formulae for converting the resources data will be shown in the website of the Rule of Law database. Yet, we understand that legal aid in some countries are lacking or not government funded. Further study is needed on how to reflect other forms of legal aid, if available, in these countries. About quality data, we look at quality data measuring efficacy, efficiency, effectiveness, etc. The existence of a rule of law related infrastructure with ample public funding may not be adequate to reflect the practice of rule of law, and such practice need to be reflected by reference to objective data that are able to review its quality. The question is how the quality of the rule of law practice, such as efficacy, efficiency, effectiveness, or various other attributes of a particular area can be properly evidenced by the objective data. In this respect, we need the analysis and judgments by specialists with knowledge of the systems relevant to the rule of law practice. Such data which reviews the quality of the rule of law practice after specialist analysis constitute the quality data. And let's look at some examples. This first example is about the number of police officers per capita and crime rate. These two parameters concern the law and order of a city, which relates to the protection of right to life under the fundamental human rights indicator that we mentioned earlier, one of the 7 fundamental human rights protection. Presumably, they are to a certain extent correlated to each other for gauging the effectiveness of police enforcement on combating crimes in the city. The two set of data that you can see here from this table can help the government concerned to analyze and figure out the optimal measures and resources in combating crimes in its city. Yet, it is common ground that crime rates vary greatly from country to country and are influenced by many factors other than the police size. For example, poverty level, unemployment rate, police spending, degree of modernization, etc., are all relevant factors. Notably, Hong Kong has been recognized as one of the world's safest cities, despite the fact that its police force size per capita is comparatively not at the top tier of the globe. As such, judgmental analysis is needed to determine how the law and order of a city can be reflected by reference to various objective parameters, including, but not limited to, the police size and the crime rate. Now let's look at another example. Settlement rate for court-directed mediation. The settlement rate of court-directed mediation, which you can see from this table, relates to the indicator efficacy of civil and criminal proceedings and dispute resolution system. These data reflect the fact that the Hong Kong courts have encouraged the use of an alternative dispute resolution procedure, including mediation, to facilitate the resolution of disputes by means other than litigation, which is a much longer process. The data demonstrate that over the past few years, court-directed mediations in Hong Kong can result in approximately 60% of amicable settlement, bringing up to a reduction of around 600 court cases annually. This would arguably effectively alleviate the burden on the court's operation and in turn increase the efficacy of the judiciary. What has been discussed above is only a conceptual model for objectively reviewing the practice of rule of law in different jurisdictions. However, the analysis is not a straightforward matter. To more fairly and accurately review the practice of rule of law, a comprehensive methodology has to be worked out with weighting parameters that draw on the rule of law indicators. This would require professional specialists to conduct inclusive and insightful study on the data and the methodology. In devising the methodology, the specialists will necessarily study how the interpretations of objective data are influenced by the uniqueness of the jurisdictions, such as the diverse culture and legal traditions in the region, different socio-economic conditions, and specific circumstances of that particular society. The diverse culture and legal traditions in different territories may, to a certain extent, influence on the practice of the rule of law in the respective jurisdictions. For example, the Confucians traditions of harmony vested in Chinese culture, where people would prefer to resolve disputes amicably with assistance of their neighbors or respected elders in their clan through conciliation to uphold a harmonious community. On the other hand, it has been suggested that the Western societies generally tend to be more litigious, with the culture emphasizing on confrontation and to determine a winning party in a dispute. In both cultures, rule of law is not at all compromised, even though the judicial structures and mechanisms are also different, but one cannot draw a conclusion that a high or low number of litigation cases alone in a jurisdiction would indicate the effectiveness of the judicial system, as such practice may be influenced by the culture of the society. It is also common ground that the economic criteria, for example, the size of a GDP, and geographical criteria like the size and population of different jurisdictions would have bearings on how certain data can be interpreted in the respective jurisdictions. For example, the legal needs in a relatively poor rural community will be quite dissimilar to the legal needs of an affluent suburban community in an industrialized country. The distribution of public funding on rule of law related aspects by different governments would hence vary. Inevitably, we also need to think about, for countries with different population sizes, GDP, or people's income levels, etc., whether the same set of data for a particular area should be treated differently. A focused discussion on the impact of cultural and socio-economic features on the access to justice will be taken forward in the next session of today's program concerning the International Youth Legal Exchange Conference 2021. Another relevant factor is that where specific events that happened at a particular time may also bring sudden variations on certain data. For example, there was a notable surge in the number of young persons aged 10 to 20 arrested for crime in 2019 and 2020 in Hong Kong. You can see from the table there. The spike in data may be viewed separately from previous year's data, possibly attributable to the extensive street violence happened in 2019, but this is not conclusive. Careful scrutiny of the data is needed to, for example, take a look of the data trend in the coming years to see, for example, whether the figures would drop to below 3,000 again. That said, this set of data has demonstrated a stunning increase of youth arrested for crime in recent years, which warrants attention on law enforcement and legal education on the youth. Another example is the data on the corruption complaints concerning election, which would normally record an increase in the election years. Accordingly, the data in election years and non-election years should be examined separately. The Independent Commission Against Corruption is clearly aware of this and have kept the complaints data related to election and non-election separately. In light of the above discussions, data distribution and trend in certain areas should be analyzed in the long term in order to examine the strength of the basic fundamentals of rule of law in a jurisdiction and how it can be improved. To conclude, what I presented just now outlines the ideology behind the rule of law database and the proposal to formulate an objective methodology for reviewing the practice of rule of law in all jurisdictions. The published version of the rule of law database will be shown very soon. I should emphasize that the database is under construction and will be continuously updated. It currently sets out the proposed questions related to the infrastructure information and proposed methodology to analyze the resource data and quality data. The raw data can be found at various local data sources' websites. It is premature to show the raw data in the database as they need to be properly processed, analyzed, interpreted, and formatted before meaningful conclusions can be drawn. So one must avoid simply referring to the raw data as a direct reference to the practice of rule of law in Hong Kong. The proposed questions and methodology are not perfect or complete yet. We hope to, with the guidance of the task force, looking at the initial proposals, develop and continuously refine the methodology based on the core objective data, so as to provide a more reliable and realistic reference to assist in self-monitoring of the progress and the practice of rule of law in all jurisdictions. This will be in line with Target 16.3 of Goal 16 of the Sustainable Development Goals of the 2030 Agenda to, within quote, promote the rule of law at the national and international levels and ensure equal access to justice for all. In the process of analyzing the objective data and developing the methodology, any informed and objective views are most welcome. I am very happy today to be given the opportunity to announce the official launch of the rule of law database. Right, okay. By clicking this button, a dedicated webpage of Vision 2030 with the published version of the rule of law database being housed will be open to public at the link shown on the slide. As said, the current version marks the first step of the Department of Justice effort, and it will be continuously developed and refined. At this juncture, I would invite our Secretary of Justice, Ms. Teresa Jang, to join me on the stage to officially launch the database.
The launch of the Rule of Law database.
Thank you, Secretary of Justice, for launching this for us, and thank you all for joining us today in witnessing the launch of the Rule of Law database. Thank you.
Thank you, Dr. So, and thank you, Ms. Jang. So we'll now have a short break. The next session on what can we learn from the International Youth Legal Exchange Conference 2021, ELEC 2021, will start at 11 o'clock. For our online participants, there is no need to log out. See you back at 11. Thank you. and gentlemen. Ladies and gentlemen, the program will begin in 5 minutes. Please be seated. The program is about to begin. Please be seated. Thank you. Welcome back. We will now begin the session on what can we learn from the International Youth Legal Exchange Conference 2021, ELEC 2021. This is a two-part session with the report on ELEC 2021, followed by the first roundtable dialogue session on culture, social, economic, and legal traditions of the rule of law for a sustainable future. We will have a Q&A session later, so if you have any questions, please write them down on the question slips provided to you on your table. Our staff will collect them from you. And for our online participants, please type your questions into the chat box on Zoom. We will address them at the Q&A session. Without further ado, please welcome Mr. Alex Fan, President of International Youth Legal Exchange Federation, to deliver the report on ELEC 2021. Mr. Fan, please.
Secretary for Justice, distinguished guests, it is my pleasure to make a report on the International Youth Legal Exchange Conference, ELEC 2021. This conference was a collaborative initiative of the Department of Justice and the International Youth Legal Exchange Federation. To give you a very quick look of what our federation has been doing, we are a Hong Kong-based legal professional organization founded by a group of young lawyers and law students. Our motto is Ad Justitiam per Rus. It is a Latin phrase. It means via law to justice. Our objectives are promoting the rule of law and legal knowledge among young people, providing law students and young legal professionals with a multifaceted platform of exchange across jurisdictions, and assisting the young legal professionals to develop their legal career. In the past years, we successfully launched various legal exchange tours to destinations including Singapore and the UK. We have our annually organized flagship program, the Mainland China Legal Internship Program. It provides a comprehensive set of professional support to law students and young legal practitioners along the development of their legal career. Let's have a look at some background facts about our conference. The theme of ELEC 2021 is Access to Justice, the key to inclusive society and sustainable development. The conference took place on 11 September 2021. Due to the continuing influence by the COVID-19, the conference was held electronically, and it is by way of a virtual conferencing. Prior to the conference, the delegation submitted their papers on their chosen topics. During the conference, the delegates gave presentations on their topics. We have set up 2 awards for those teams with the best paper and the best presentation. In total, we have 11 youth delegations from different jurisdictions in the Asia-Pacific region. Each team contains not more than 3 delegates. All of the team members must be aged between 18 to 45 with legal or dispute resolution background. Each delegation is nominated by a particular university or professional institution of the respective jurisdiction. You can now see on the screen the 11 nominating institutions for ELEC. They are respectively Bar Association of the Kingdom of Cambodia, Department of Law, the University of Hong Kong, Department of Global Legal Studies, Faculty of Law, University of Macau, Faculty of Law, Chulalongkorn University, Faculty of Law, Universitas Indonesia, KCAB International, National University of Singapore, School of Law, National University of Mongolia, School of Law, Tsinghua University, School of Law, Vietnam National University, Hanoi, University, Malaya. May I now go back a bit to the philosophy behind ELEC? The project theme of ELEC 2021 echoes the vision 2030 for the Rule of Law initiative launched by the Department of Justice. In particular, the theme connects with SDG, the Sustainable Development Goal 16 of the United Nations, namely to build and maintain a fair and rule-based society underpinned by the rule of law through collaboration with stakeholders for sustainable development for all. The main objectives of our conference are to provide a cross-jurisdiction platform for for youth with legal and dispute resolution background in the Asia-Pacific region to share and exchange their views on the legal system and advancing access to justice in their respective jurisdictions. And through the conference, to learn how cultural, socio-economic factors and legal traditions may interplay with the rule of law so as to facilitate a more holistic study of the rule of law and access to justice system of the respective jurisdictions. Under the conference theme, the participating delegations gave presentations on the general topic of how cultural, socio-economic, and legal traditions have impacted on the access to justice system or mechanism in their respective jurisdictions. And the teams explored the particular issues of efficiency and effectiveness of formal legal protection, availability and adequacy of legal aid, legal awareness and public education, adequacy of redress or compensation through adjudication, enforcement and civil society oversight. Now I will quickly share with you the subtopic chosen by the respective teams of our 11 delegations. Let's have a quick look. We start from Cambodia. So the Cambodia team focused on the availability and adequacy of legal aid in Cambodia. The team discussed the challenges and efforts taken by various stakeholders in promoting legal aid in Cambodia. They provided a reflection on the development of legal aid's availability and adequacy in Cambodia and also explored alternative and innovative solutions for addressing those challenges. Next team is our Hong Kong team. The Hong Kong team addressed three main issues on the rule of law. First, legal awareness and public education. Second, adequacy of redress or compensation through adjudication. And third, review of the legal aid services provided to the disadvantaged groups in Hong Kong and the effects of access to justice on building an inclusive society for sustainable development. The third team is Indonesia team. They analyzed the legal positions of an institution called Panglima Laut. It is a customary institution in Aceh province that deals with fisheries dispute by enforcing and supervising customary laws imposed by fishing communities with Indonesia laws enforcement and its influence, similarities and differences to the formal court of fisheries. The team provided analysis from the perspective of both the fishermen and the authorities in relation to the two institutions. Next team is Macau team. They reviewed the bill of the new legal aid law of People's Republic of China through comparative study on the legal aid legislations in both Hong Kong and Macau. The team made some recommendations for the improvement of the bill. Our Mainland China team, the Mainland team discussed the role and the inconsistency between the administrative authority and the civil court in determining price fraud and for the protection of customer rights. The Chinese team explored how to reconcile the administrative regulations and the civil law norms to achieve a consistent outcome for price fraud cases. Next, we have Malaysia team. The Malaysia team discussed the legal pluralism of a system that incorporates common law and Sharia law with a focus on Sharia family law. The team addressed how to ensure the maximization of Sharia court's potential and its significance in upholding the rule of law and maintaining the status quo of legal pluralism in Malaysia. The next team is Mongolia team. The Mongolia team discussed the role of the constitution adopted in 1992 and its subsequent amendments in 2000 and 2019. In particular, the team addressed the factors that influenced the constitutional amendments and its socio-economical significance. They also assessed the pros and cons of the constitutional amendments and prospects of these amendments in the legal system of Mongolia. And we have Singapore team. The Singapore team discussed the availability and adequacy of legal aid in Singapore, as well as the alternative platforms for access to justice, for example, small claim tribunal, community justice center, etc. The team evaluated the influence of the socio-economic factors, such as the race, religion, politics, etc., on the development of legal aid and alternative platforms for access to justice. And next, we have South Korea team. The South Korea team discussed the utility of blockchain and smart contract technology in dispute resolutions. According to the Korean team, such technology could clearly define the rules and procedures for resolving a dispute and automate the implementation of these rules and procedures to minimize any human error relating to the notice, timing, and other procedural requirements. Next team, we have Thailand team. The Thailand team discussed the difficulties faced by undocumented migrants in Thailand in accessing fundamental rights, including access to justice, health care, and fair remuneration. The team proposed recommendations and potential legal frameworks to encourage stronger protection of the rights of the migrant workers. Finally, we have Vietnam team. They discussed the role of civil society in Vietnam in providing access to justice in the context of the socialist rule of law, human rights protection, and judicial independence. The team also compared the role of civil society in single-party states and multi-party states concerning freedoms of the press, expression, and assembly. We were very honored to have distinguished legal professionals, both local and overseas, to serve on our adjudicating panel. They are Justice Patrick Chan, Mr. C.M. Chan, who is with us today, sitting in front, and also Mrs. Pranami Momodu. In this conference, as I said earlier, we have 2 awards for the delegates. First, the Best Paper Award goes to the delegation from University Malaya, our Malaysia delegation. And the Best Presentation Award goes to the delegation from National University of Singapore. On behalf of the organizers, may I take this opportunity to congratulate the winning teams once again. And in fact, their representatives are joining us in the next panel discussion session. You will meet them very soon. Finally, may I share with you some highlights and snapshots of the conference. And we have SJ to be our guest of honor to deliver the welcome speech. And this is some snapshots of the taken during the conference. Our judges. So finally, may I express our gratitude to the Department of Justice and Secretary for Justice, Ms. Teresa Chang, for giving our federation the opportunity to take part in this meaningful project. This is the end of my report. Thank you very much.
Thank you. Thank you, Mr. Fan. Please take a seat. And now, let's move on to the first roundtable dialogue session on culture, social, economic, and legal traditions of the rule of law for a sustainable future. Let me introduce our moderator and panelists for this session. Let's welcome Ms. Finis Jang and Mr. C.M. Chan to the stage. Let's give them a round of applause. Joining us online, we have our panelists, Mr. Jeffrey Jerry J. Mosio, Ms. Joanna Surel Anak John Wang, and Mr. Lim San Shin from the University of Malaya, and Mr. Sifan Huang and Ms. Glenda Tan from the National University of Singapore. So Ms. Jung, the floor is yours.
Thank you and good morning to everyone. Thank you for joining me for the first roundtable dialogue section of the inaugural Rule of Law Signature Engagement event. I'm really honored to be moderating the session this morning. Joining me live on stage, besides Alex, who we've been introduced to earlier, we are very, very delighted to have the President of the Law Society of Hong Kong, CM, welcome. And joining us virtually, we have very impressive law students. From the National University of Singapore, we have Stephen and Glenda. They've been awarded with the Best Presentation Award from ELAC 2021. And from the University of Malaya, we have Jeffrey, Joanna, and Shanxian. They've been awarded with the Best Paper from ELAC 2021. So there are similarities and differences of cultures from different jurisdictions. And through this follow-up session from ELAC 2021, we hope to provide not only an opportunity to connect regional youths and practitioners to share their vision for the future of the rule of law, but also to invite all of you here to join us in this one-hour journey as we explore culture, legal traditions, and by understanding these elements, how can we further advance the rule of law? So As I was really excited preparing for this session, I would like to share with you a really short story. So I decided to wear green to match one of the key colors of our legal week this year. And as I was thinking, okay, so what does the color green means in different culture sense? And I did a quick Google search. So, if it's wrong, it's Google's fault. And I found that in North America and Western Europe, green is often associated with good luck. But in Latin and South America, that's viewed negatively. So while Irishman wears a green top hat on St. Patrick's Day, I think in Asia, men would not want to be associated with wearing green hats. And you know why, that's the reason. Okay, so with this little short introduction, may I first pose the first question to our delegates from the National University of Singapore, Stephen and Glenda. I want to talk a bit more about culture aspect. We all know that Singapore is a multiracial, multi-religious society. And it is unique to Singapore to have enacted legislation, the Maintenance of Religious Harmony Act in the 90s, which was recently updated in 2019. And I understand that in his National Day rally speech, the Singapore Prime Minister Lee Hsien Loong spoke about the intention to pass a new legislation called the Racial Harmony Act. So can you tell us more about this legislation, and do you think there's a need to have relevant legislation in order to maintain a harmonious society?
Yeah, thank you very much. We're both very honored to be here. So thank you for inviting us again. So I think your question comes in two parts. So first, to do with the 2019 amendments to our unique piece of legislation, which is the Maintenance of Religious Harmony Act. And of course, this new proposition that was made just this year, actually, for a new racial harmony law. So we have this thing called the Maintenance of Religious Harmony Act, which is specifically for regulating laws around maintaining religious harmony. But I guess recently this year, there has again been this proposition for a new racial harmony law. And I guess that was more, that was sort of prompted by a few incidents that happened this year to do with, racism, I guess brought about by the COVID-19 pandemic. So I think I'll address the first question to do with the amendments in 2019 to the Religious Harmony Act. So the Religious Harmony Act was updated in 2019, and that was in consultation with religious leaders in Singapore. And what the government said was that these amendments were designed to help the government respond more effectively to threats to religious harmony, and also to strengthen safeguards against things like malicious foreign interference. So it was meant to address really two key concerns. The first was the use of the internet to spread hatred and offensive content against religious groups. And then the second, of course, was to address increasing foreign religious interference. So the Maintenance of Religious Harmony Act was enacted in the 1990s. So back then, they didn't have things like the internet and online social media in mind. So we think this is a step in the right direction in that it addresses the modern realities of technology and how the internet is used to spread offensive and hateful content. And so what these 2019 amendments came by was really just 4 key amendments. So the first was to ensure that religious organizations were free from malicious foreign interference. The second was to introduce this thing called the Community Remedial Initiative, which was basically to help those who were accused under the act of injuring religious feelings to make amends. The third thing was to give priority to the effect of restraining orders issued under the act. So prior to the 2019 amendments, you needed 14 days of notice to issue a restraining order for someone who was accused of offending religious feelings in Singapore. But now, given the spread of technology and how the internet works, restraining orders that are issued under the act have immediate effect. And then fourthly, penal code offenses related to religion were now consolidated under the Maintenance of Religious Harmony Act. So previously, there was a bit of overlap and uncertainty between how different acts address religious and racial harmony, but with the 2019 amendments, it's been more clear. Offenses related to religion are now dealt with under the Maintenance of Religious Harmony Act. And then I think this isn't one of the things that affects the act itself, but then of course there was Section 74 of the Penal Code, which was amended to increase the maximum punishment for religiously aggravated offenses. So those are really the 4 plus 1 key amendments that the 2019 amendments brought about to the Religious Harmony Act. We think it's a good step in the right direction to address how technology and the internet can really advance more quickly and more widespread the spread of offensive content. And I think I'll let Glenda address this year's proposals for a new racial harmony law.
Yeah, thank you so much, Zephyr, for your discussion on the amendments to the Maintenance of Religious Harmony Act. So now I'll take you on the discussions on the proposed Maintenance of Racial Harmony Act. So in recent years, beyond just religion, race has divided Singaporeans from all classes. There have been quite a few incidents where Singaporeans may not have been the most tolerant of individuals from other countries or races. For example, I think PME in the National Day rally talked about an incident where netizens picked on the town council celebratory banner showing an Indian family, even though other banners had featured other races. They accused the government of being pro-foreigner and pro-Indian. This comes after widespread rage about CICA, a trade deal with India, which some Singaporeans say has allowed for far too many Indian workers in Singapore. While Singapore has long been heralded as a very tolerant nation, such incidents indicate that race still divides Singaporeans to this day. As our Prime Minister noted in our National Day rally, minority races still face disproportionate difficulties when they look for jobs or apartments to rent. This is where the Maintenance of Religious Harmony Act comes in. The proposed Maintenance of Racial Harmony Act was proposed in 2021 National Day rally to deal with the racial tensions still present in Singapore. It includes softer measures that can order someone who has caused offense to stop doing it and to make amends by learning more about other races and mending ties with them. The softer measures help rehabilitate Singaporeans instead of punishing them. It seeks to serve a similar salutary purpose to the Maintenance of Religious Harmony Act, as Zephyr mentioned, by signaling what Singapore society considers right or wrong and nudge people over time to behave better. However, this is just a short-term fix for a long-term, very serious issue. The real solution to racism is to change individual and social attitudes, and this takes time and effort. In doing so, we need to take note of the attitudes of people from different generations and how foreign developments like Black Lives Matter may impact Singaporeans. While Singapore may be one of the few countries in the world where people from different races and religions live peacefully together, the recent amendments to the Maintenance of Racial Harmony Act and the proposed Maintenance of Racial Harmony Act shows that our journey to true racial and religious harmony has just begun.
Okay, thank you. Thank you to our law students from the National University of Singapore. So can I invite CM and Alex to perhaps share your views on, we have example from Singapore with a legislation on racial harmony and religious harmony. Do you think this is necessary, or is there a need to legislate related cultural aspect and governing the behavior related to culture?
Thank you, Venus. In fact, let me congratulate the students from Singapore and Malaysia again. All these familiar faces. We spent a lovely morning on a Saturday. Very great presentation from all of you. It's actually very
questions from the panel.
Absolutely, very, very challenging questions. It's actually very timely when we talk about racial harmony Act in Singapore, because in Hong Kong we're actually looking at this particular legislation closely. Very interestingly, Hong Kong is also a multi-racial society, but even within the Chinese majority population, there are different ethnic minority groups. So the government is actually actively looking at how to sort of rationalize, how to actually regularize this aspect. So it's actually very timely when you raise that. I'll take that into consideration when the government consults us. Thank you.
Alex, any views?
Actually, like as CM mentioned, like Singapore, there are many different ethnic groups in Hong Kong. For example, the Chinese community and also those ethnic groups from the Southeast Asia countries, due to historical reasons. And in fact, for those countries or places with similar situation, they adopt different measures to tackle the issues or address the issues. For example, Singapore in this year recently passed a new amendment legislation to address some new issue arising from the new challenges nowadays. And after all, if you impose a legislation to deal with the situation, to some extent it is necessary, but on top of that, really we also need some administrative measures or government policies to enhance the harmonious community and the need to protect those ethnic groups. For example, in Hong Kong, the Chinese community is the main racial group or minority group, and in Hong Kong we have some basic protections we have the racial discrimination ordinance and afford some basic protection to those groups. But of course, it depends on the legal traditions, and as I mentioned in my report, the socio-economic factors of each particular jurisdiction in order to find the best way to deal with it. And now we have the example in Singapore, and we also have different way to deal with it in Hong Kong and also in our motherland in China.
Thank you, Alex. Would Jeffrey and your team, would you like to chip in?
Yeah, I think in Malaysia, particularly, maybe we don't have what we call a racial harmony ordinance, but we have a law called the Sedition Law, which is left through the colonial British, which guides the sensitivity of the culture and the religious sensitivity in the society. However, there are criticisms that the law is a bit archaic, as it's been left by the colonial British. But at the same time, we do believe there is a need for a racial harmony ordinance or sort of law, but maybe there's more review to be made and to understand the dynamic, as Singapore has mentioned, or the Singapore delegates have mentioned about the spread of racial hate towards people online and through means of technology. And I think that should be updated.
All right, thank you. Before we jump into the next topic, just back to Stephen and Glenda. So after hearing the sharings from our different panelists, do you think what's the way to go in moving forward for a sustainable future, for more inclusive society? Is it legislation, or is it changing the mindset as Glenda suggested?
I think it's a bit of both. So of course, what you hope is that you would change people's mindsets, but it doesn't start that way that easily. I mean, it always starts with legislation and the law. That's what this whole conference is about. And we think that, again, these new amendments, whether it be to the Maintenance of Religious Harmony Act or the new proposed racial harmony law, are a step in the right direction, especially for a country like us. I know there are countries that would disagree with Singapore's approach. Maybe they think it's too much of a police state. But given that we are the most religiously diverse countries in the world, and as well as one of the most racially diverse, it is important to protect different groups and minority interests and ensure that different groups, be it religious groups or racial groups, can coexist in harmony. So I think we see these amendments and these new laws that are being proposed as a step in the right direction, in that they reflect modern realities. So of course, the 2019 amendments reflecting how technology can very quickly spread hatred and offensive content, and of course the new racial harmony laws that's being proposed to sort of address the realities that we have nowadays, where people can spread very offensive content online very quickly, and I guess new attitudes that have been brought about by things like the COVID-19 pandemic.
Anything to add from you, Glenda?
Venus, can I add a little bit?
Oh yes, Alex, please.
Just
Sorry,
when we talk about inclusive and diversity, I just give you an example. This is actually an example I really like to use. I was elected the president of Law Society 2 months ago, and I used to be one of the vice presidents of the Hong Kong Law Society. And during my term as a vice president, Melissa Pang was the president. She's Chinese, Christian by religion. Myself, Chinese, and I don't have any religious belief. I have 2 other vice presidents, one of which is a Jewish, is an English nationality, a Jewish by religion, living in Hong Kong. And my 3rd vice president is actually a Muslim. also living in Hong Kong. So I always said that the Law Society, the office bearers possibly have the most diverse in terms of religious background and cultural background in the whole world. I should actually write a paper on that, in fact. And going back to the racial harmony point, it's very interesting with Singapore, Malaysia, and Hong Kong here. Even though we are all, as I can see, are Chinese ethnic background, but in Hong Kong, Chinese made up of 90% of our population, over 90%. In Singapore, I believe it's roughly 70% Chinese. In Malaysia, however, it's roughly 20 to 25% Chinese ethnic. So in that sense, it again makes a very big difference in terms of the government's thinking in terms of legislation. So that's my little 2 pennies from me. Thank you.
Thank you for sharing, CM. All right, next, let's look at the concept of legal traditions. For Jeffrey, Joanna, and Shanshan, in your paper, you actually talk about the Malaysia being a pluralistic legal system with common law, civil law, and customary law, and particularly Sharia law. Perhaps for today's session, we can focus more on Sharia law and the role of the Sharia court. My question to you are, do you think that such legal traditions should be preserved? And if there are conflicts between the Sharia court and the civil court, how should this conflict be resolved?
I thank you, Ms. Chen, for the question. Well, this I will be answering with my colleagues too, Joanna and Sanchez. And I will be first giving you a brief overview of how things had started and is going on. And Joanna will present to you or discuss the status quo of things. And Sanchez, my colleague, will further divulge on what is the future that holds for the pluralistic legal system in Malaysia. So the Sharia system has not started out of nowhere. It has been since the 15th century when the Malacca Sultanate happened and where the Sultan embraced Islam. The administration of Islamic law has been started. And while throughout the century, when there's no when the Sultanate is still happening, Islamic law has been already administered in villages and also in communities by local leaders or local Islamic leaders called Qadis. While even during the Portuguese and Dutch administration in Malaysia, or before that in Malacca or Malaya, there's been evidence that the Islamic law is administered informally by all these local leaders. However, when the British came and they brought with them the common law system, the Islamic law or the Sharia law has been infused into the English courts and made actually the subject of English courts. And by that sense, the English judges hear Islamic cases and also take upon themselves to interpret Islamic law with the help of local leaders and customary law experts. While when Malaysia attained independence, this continued on where civil courts inherit the English courts left by the British, where they continue to interpret the Islamic law within the Sharia, within the civil courts. Although they are Sharia courts, this means that a matter that started in Sharia court could be appealed to civil courts to be reviewed by civil courts. However, in 1988, when we have a constitutional amendment of Article 1211A that specifically exclude the civil court review on Islamic law matters, and hence the Islamic law matters are now Islamic law matters specifically to family law, as we discussed in our paper, is under the purview of the Sharia courts. That being said, civil jurisdiction and Sharia jurisdiction has always been in conflict, and this has all subsisted until today. And I'll pass to my colleague, Ms. Joanna, to continue to discuss on that.
Thank you to Ms. Venus, panelists and attendees. So in the present day,
Sharia courts are seen as the defender and protector of the Muslim faith. And as reflected in cases that has been heard in civil as well as Sharia courts, Sharia's court's jurisdiction is only limited to personal law, as mentioned by my colleague Geoffrey. So examples of personal law comprises of apostasy, child custody, breach of promise to marry. But taking into account the diversities of religion that we have here in Malaysia, the decision of Sharia courts prevails over decisions that is made by civil courts when it comes to matters regarding Islamic personal laws. In any case, whilst the sanctity of religion is important to be safeguarded, Sharia courts also emphasize on public interest. So I will now illustrate this with the landmark case of Indira Gandhi. So the case of Indira Gandhi was first heard in civil court. However, the importance of this case is that the civil court itself recognizes the jurisdiction of Sharia court, in which Sharia court can only review personal law matters that civil courts cannot step on. So in administering culture, or as we call it adat in Malaysia, the Sharia court also recognizes marital property, or as we call it harta sepencarian. So in other words, property that is jointly acquired by husband and wife during the subsistence of marriage, in accordance with the conditions that is stipulated by Islamic principles. So to keep it all short, Sharia court actually makes decision based on Islamic principles and not so much on precedents as what has been followed by the civil courts. So this is due to the influence of customs and teachings of the Quran that applies to each facts of the case. So I shall now end my presentation and pass it on to Sanxian, future of Sharia courts. Sanxian?
Hello, can you hear me? Testing.
Yes, yes.
Okay, a very good morning. Warm greetings to ladies and gentlemen. Let me first congratulate the organizer for this excellent initiative in organizing this Hong Kong Legal Week, and thank you for inviting Malaysia to be part of it. I'm very happy that we are able to keep each other abreast of our respective jurisdiction. Malaysia is proud to be a nation of multi-ethnic, multicultural, and multiracial society, where the nation is made up of races like Malay, Chinese, Indian, indigenous people, and others. We live together harmoniously as a Malaysian family, Keluarga Malaysia, which is introduced by Prime Minister. Malaysia has been known as the strong proponent, advocate of building sustainable and inclusive society underpinned by the rule of law. The current namescape of legal pluralism in Malaysia, as stated by my esteemed colleague, can be traced back to a classically plural society with a legal system which is inherited from the colonial times, that is a blend between the common law and Sharia law. Malaysia is happy and boasts the dual legal system, which can coexist harmoniously and peacefully, in which the civil court only have the exclusive jurisdiction and power may be conferred by or under the federal law, as according to Article 121 of the Federal Constitution, the Supreme Law of Malaysia. However, Article 121 Clause 1A of the Federal Constitution stated that the Sharia court or the Muslim court have the jurisdiction only over Muslim matters, also stated by my esteemed colleague, as stated in the Schedule 9, these two, which is under the state list. As we know that the Muslim and the Sharia courts, all this jurisdiction is actually under the purview of the state, which is the state assembly, and make a law at enactment for the Sharia matters. Thus, the jurisdiction have been provided clearly in the Constitution and the Act of Parliament to ensure that the purview of court do not interfere or disturb each other. The dual legal system should be preserved in the times to come. As we know, Rome was not built in one day, and we need efforts by all the nation and people to consolidate our effort to build sustainable legal system, and also to ensure that the dual legal system in Malaysia can view and hear the specific legal cases efficiently and specifically in regards to civil cases and also Muslim cases. And also it's important to ensure that all the interests of the citizens in Malaysia are protected and upheld, in which we have Muslim people are protected, their interests under the Muslim courts, and also we have native courts and also civil court. So anyone will be happy and their right will be protected and justice will be served. As referred to other jurisdictions, Brunei has also legal pluralism, which consists of common law, custom, and Sharia and Kanun. And in Singapore, our esteemed colleague here today, Singapore also having common law and Muslim law. So I think in the future, we will call upon all the nations, and especially Malaysia, we will continue to support this legal system to ensure that we will work harder and also introduce more initiative to keep ourselves along with the digital world development, and also to ensure that the legislative branch, which is the parliament, can provide clear jurisdiction of what is the jurisdiction and the method that can be tried under the Sharia court and the civil court, to ensure that there is no conflict and we will live harmoniously, to ensure that we can realize Goal 16 of the SDG, which is peace, justice, and strong institution. And strong institution will be referred to the strong institution of a legal system. And last but not the least, Malaysia delegates would like to call upon the international collaboration to work together to find our common ground and also to build a sustainable future alongside with the Goal 17 of the SDG, which is a partnership for the goals. So in the end, we would like to hope for a better future underpinned by the rule of law, in which all legal systems will benefit the people and stress the constitutional supremacy and ensure that the rule of law will be served and will be emphasized in all cases and matters. Thank you.
Thank you, Jeffrey, Joanna, and Shanshan for sharing with us the unique legal system in Malaysia. I have a question for CM. For the benefit of our overseas audience, I think this question is one from an overseas audience. They would like to know about the role between the role of the legal system in Hong Kong, between the common law system and that from China, civil law being practiced. So can you share with our audience the legal system in Hong Kong under the principle of the one country, two system, please?
Thank you, Venus. This is actually a good opportunity for me to explain a little bit about Hong Kong's unique system. Venus mentioned it's called one country, two systems. Under the Basic Law, which is the constitutional document for Hong Kong, Hong Kong maintains its own legal and economic system after the handover in 1997. And as you all know, before 1997, British ruled Hong Kong, and common law was introduced to Hong Kong. So Hong Kong still maintains its common law tradition with our own independent judiciary, and Beijing will not interfere with the running of Hong Kong. We call it high degree of autonomy. So this is quite unique, especially in the light of what you've said about Sharia law and civil law, the interplay. In fact, very interestingly, in Hong Kong, we do have some indigenous people, our version of the indigenous people in the rural villages. There are still some very traditional Chinese customary law still applicable in Hong Kong, and their rights are actually protected under the Basic Law. So for example, this is quite interesting, there are marriages before the 70s, and actually there are people who have concubines, so more than one wives in Hong Kong. So if you get married before the marriage ordinance in 1971, I think, then you can actually still have the old Chinese customary tradition to have more than one wife. Another example is land ownership. We call it Ding Kun in Hong Kong. So in some of the rural area, they actually retain their rights to have land ownership, to be able to build a small house on top of a piece of land. But this is actually not applicable to all other citizens. So again, how do you interplay this with basic human rights? So a very, very interesting question and difficult one too. Thank you.
Yes,
May I
Alex,
chip
please.
in? Yeah, thanks, Venus. Yeah, I entirely agree with CM. If we talk about our one country systems and the applicability of basic law, we have also to mention the Constitution of China, because everyone we have basic law is due to the fact that we have Article 31 of Chinese Constitution, which expressly authorized the establishment of a special administrative region, and we have a set of law that is basic law to prescribe the system, the legal system we have. And this is another example in addition to our Malaysian friends, their Sharia law system. And each country has their own wisdom, have their individualized approach to how to resolve the interface of different systems, the emergence of different systems. And after all, what is important is legal certainty. Today we have the topic rule of law, and I guess there will no dispute that legal certainty is a common to any types of interpretation of rule of law across the world. And so long as the boundary or the boundary of the application of, say, Sharia law system in Malaysia, or the boundary of the indigenous rights in Hong Kong, the new territories, and so long as the boundary is clear, then the court can easily, or they well accustomed to apply the rules in order to define the rights and liabilities of citizens. For example, in Hong Kong, we, apart from those small house policy or the marriages and concubines before 1970s mentioned by CM, nowadays, Hong Kong courts is still well accustomed to recognize those Chinese customary trusts, which is unique to the setting of indigenous residents in new territories. And this Chinese customary trust is legally effective, and also they are completely lawful alongside with what we have under the common law trust. This is a very good example. And where the courts that can do their work with reference to those past precedents and principles, and to have the citizens' rights and liabilities well defined.
Thank you, Alex and CM. Well, we've heard about the culture, and we've heard legal traditions and how they interplay with the rule of law. And this morning we've heard the Chief Justice speech on the rule of law. And with that, it brings me to my third topic with Alex. ULIF has organized like mainland and overseas exchanges with youth and undergraduates. So during your experience with exchanges with the youths from different jurisdictions, do you think, or have you observed that there's any different cultural, or based on their cultural background, that they have different understanding in the rule of law, or is there any similarities you observed?
It's an easy and difficult question, but I would like to share my observations during those exchange programs. In fact, our federation, ILIF, in short, we have, as I mentioned in my report earlier today, we have overseas exchange tours. We have held tours to UK, to Singapore, and we also annually held our flagship program, internship programs. We brought more than 100 Hong Kong law students to have internship for a month in either Beijing or Shanghai every year. And from those experiences, I observed that the law students or young lawyers of different countries or places, so far as those students or young lawyers I have met so far, they are all fascinated about their own legal systems. And that's the first point. And second point is that most of the youngsters I've met, they have a very strong law-abiding spirit. As all you know, different legal traditions, different legal systems have its own history, socio-economic situation, legal tradition, etc. And after all, the real objectives of legal exchange is not really to find so-called the best practice of the legal systems, of the rules of the jurisdiction. But the more you know about the other countries or jurisdictions' legal system and the rules they have, and the more exchange you have with their youngsters, and then we can know more about our own system. Because through the process of exchange and maybe more in-depth comparative studies, then you will discover more about your own system. You will widen your perspectives.
Would you like
yeah,
to,
sure.
yeah.
Just perhaps share with you some of the figures. First off, in Hong Kong, we still have a divided legal profession. We still have solicitors and barristers. And the Law Society of Hong Kong regularizes all solicitors in Hong Kong. We have 12,000 members, solicitors. I actually looked at the figure last night. With those less than 5 years post-qualification experience, made up about 20% of our membership. So 1/5 of our members are under 5 years qualification experience. And under 7 years, I think the percentage goes up to almost half, 40%, something like that. So what I'm trying to say is we have a big chunk of our membership are very young members, and they are relatively new to the profession, and their needs are very different. As the president, I do need to take care of their needs and their hobbies and habits. For example, I do need to think about using social media more to communicate with them. We still use faxes, in my generation. So for them, it's really outdated. So this is actually, from a policy angle, not only the Law Society, but the Hong Kong government should actually think more about this interesting trend.
Thank you, CM. Well, I've got a question for Stephen Glender. After hearing that all these exchanges that ILIF actually organized in the past, as a law student, would you be interested to join similar events, or do you think we should think of the box and go more on social medias and do more promotion on rule of law online? What do you think?
Thank you for the question. So I think, in my opinion, the work that ILIF does is actually very meaningful, and especially through this competition, I learned a lot about other countries and about my own country as well, as I did some research. And so I think such events should continue. I think they are a wonderful platform in which students from all over the world can learn from one another. And I think that is very meaningful in itself and presents a very interesting opportunity that we will not have otherwise. Yeah.
Stephen, would you like to add to that?
Yeah, I fully agree with Glenda. I think it was, even if we didn't win any award from this, from this experience, it was an award in itself to learn about how other countries, how rule of law works in other countries, and the different presentations that were very diverse, but all equally interesting in terms of the topics they were presented and how they approached the theme of this presentation. So I fully agree. I think this was a great opportunity, and thanks again for it.
And Jeffrey or Joanna?
Hi. Yeah, I actually do agree with Glenda and Stephen. We actually learned a lot from this platform. When we first listened to presentation from Cambodia, we were amazed because, oh wow, it's something that we were not taught in schools or even bothering to read about it. So it's a great exposure to us. And yes, we learned a lot actually about Malaysia and how Sharia actually works. Like Geoffrey and I were actually from Borneo, so we know roughly a bit on our customary law. But when it comes to Sharia, it's something really new to us. And yes, we actually learn a lot and expose ourselves to our own law in our country.
Shanshan?
Yes, thank you so much. I would like to commend the effort, amazing effort and remarkable achievement done by ILIF and also the organizer today, because I get to learn about the other jurisdiction and also about how we can work together collaboratively to move as a family to find peace and unity and harmonious legal system. And most importantly, mentioned by one of the panel just now, legal certainty. I think this is important and should be emphasized in all nations to ensure that we can always know what is the law about, and also to ensure that the rule of law can be upheld all the time. So definitely all the effort is laudable, and I look forward to more events and collaboration with ILIF and the organizer. Thank you so much. Have a good day.
And also, let me take this opportunity to thank the Secretary for Justice for actually coming up with organizing ELAC for our students in the region, and for Alex for helping out with the organization of the ELAC. And it's actually under one of our Vision 2030 initiative under the umbrella of Enrichment Program. SJ has mentioned it earlier this morning, but just want to recap. The Enrichment Program, we hope to actually connect regional youths and reach the legal practitioners so that they could also contribute to the rule of law for the region and beyond. So for our last topic, I would like to explore more on the ways we can advance the rule of law. And the Law Society and lawyers in general, they have a vital role to play in upholding a rule of law. As a newly elected law president of the Law Society of Hong Kong. CM, do you think it is important that we have youth participation for the future? And what ways can we empower them to actually contribute to the rule of law?
Sure. Let me just remind everyone that the United Nations Security Council, the most important body of the UN, passed a resolution in 2015 saying that the youth is our future, number one, and they're actually the key to maintain peace and security. It's a UN Security Council resolution. So that's first off, very important youth work. We place huge emphasis in the Law Society. I mentioned the figures. We have a growing number of young membership. So we have set up a special group within our Law Society, Young Solicitors Group, to take care of those with 5 years or less qualification years of experience. So they have their own different sets of goals, activities. Like I said, they use more social media, for example. They may not like a physical forum like this. So they have a very specific set of needs and goals. So we place a lot of emphasis on that. Number two, the Law Society organizes a flagship program called Teen Talk. It's actually a program, outreaching program to secondary school students. We gather them together once a year, give them a particular topic on the rule of law. For example, we have moot competition. We visit the legislature in Hong Kong. So a judiciary as well in the past. So again, this is a very important part of our work to help them understand the importance of the rule of law. And the problem of the rule of law is, of course, there's no single legal definition for the rule of law. So we do need to actually teach them what a rule-based society should work. So that's some of the initiatives that Law Society has taken in the past. Thank you.
And just one more question, CM.
Sure.
And we have really impressive students joining us for this panel today. And what advice would you give them as aspiring young lawyers? How can they contribute, while they're in school now, and in future they'll become the young lawyers? So what advice would you give to them?
I think hardworking, that's number one. I mean, especially in a common law, as a common law lawyer, you do need to read a lot of cases. And that not only domestic cases, as you all know, we need to make reference to a lot of cases from other common law jurisdictions. So the research skills, important, hardworking, statutes, but more importantly to me is actually look at it from a wider perspective. We always debate in Hong Kong with my friends that whether the legal profession is a business. Is it a business? Of course, we live in a capitalist system. A law firm, a lawyer, we need to earn a living. But don't forget, in Hong Kong at least, a solicitor is an officer of the court. We owe a greater duty to the court, not only a profit-maximizing individual or law firms. So think of it that way, a greater role in the society as a lawyer. Thank you.
Thank you. And Alex, as a practicing barrister, what are your take on this?
Of course, I entirely agree with what CM has shared with us, but back to the first question raised by Venus, how to further advance rule of law in society. I want to stress, of course, whenever you mention anything about law, legal rules, then the first thing came into your mind would be the judges, the court, the lawyers. But I want to say, rule of law is not only for the legal profession, the legal industry. Everyone in society has their responsibility to make it happen and make it continue to happen. So to advance the rule of law in Hong Kong or in any other societies or jurisdiction, of course, the public is important. After all, no matter how good the rules you have, how good the system you are practicing, after all, it has to be administered by people. So people are important, and youth is our future. Of course, I entirely agree with CM. The education about rule of law, so far as youth is concerned, it is very important. That's the thing I want to add. And the second question about advice.
Advice for young lawyers.
I would say I'm still young. I still need some advice from senior lawyers like CM or SJ or Thomas. But I would say for lawyers, of course, you have to know your role, respect your role. As CM said, your overriding duty to the court, to the system, in addition to the fact that you have to earn your living by this profession. And to form your independent view and judgment is also a very important skills. Or whenever you encounter some parties from different places, different countries, of different backgrounds and traditions, also respect why they are here, why they are like this from the historical perspective, as what CM said, wider perspective. So just don't focus on your own perspective. That's what I want to add.
Thank you, Alex. Okay, so we've heard from Alex and CM from this perspective from the president of the Law Society and practicing barrister. To Stephen and Glenda, what do you think, or what do you expect more from your Law Society in Singapore, or how do you think they should do more to empower you to contribute to the rule of law?
Thank you for that question. So I think the Law Society of Singapore in recent years has set up efforts in order to engage students. For example, we have Law Society internships or opportunities that we can take hold of. But I think one thing that the Law Society could do in Singapore perhaps would be to perhaps learn from Hong Kong and just to come up with similar competitions like current competition, because it does help engage us youth and make us think in a more comparative fashion. And I think that's very useful, especially since we live in a multicultural world, and it's very important that we understand things from a multinational perspective. So I think that will really help to engage us and our curiosity on different parts of the world, which I think is very important for today's age.
Yeah, I'd have to agree with Glenda. I think student engagement is definitely one thing that we can improve on. So different events, not just locally, but also at an international level, because I think there's a huge difference between how we learn law in school and how law is actually in practice. Not to say that school doesn't teach us how law is in practice, but I think most of us can agree that once we come out of law school, there will be a difference between the kind of skills, or I guess the kind of way we approach law when we're studying it, as opposed to the kind of way we approach law when we actually apply it in real life. Be it if you're on litigation or you go into the more corporate fields. And then, of course, there's a difference between how law is applied in your own jurisdiction and, I guess the experience that we've had when we see how law is applied in other jurisdictions. So, student engagement, not just in terms of law and practice, but also how law works in other countries, I think would really broaden horizons for Singaporean students, as well as for other countries that, we could get involved as well.
And I think I'll ask Sangshan this question because we are aware that you have been awarded by the Johor State government for your recognition of accomplishments in contribution in empowering people. So can you tell us what should be done, or what more can we do to empower young lawyers to contribute to the rule of law?
Yeah, sure, and definitely. So I think we should know what is the mission and vision of each country and how we can achieve rule of law and sustainable development, and also emphasizing the roles of youth, especially in nation building, and also in all fields. For example, like politics, we should have more youth in politics to avoid gerontocracy, which is more senior politician. But also we need senior politicians to guide the young politician. So I think this is important. Like in the economy, we should recognize the role of youth as the C-suites or chief executive officers, chief legal officer, and all this. So we should give some roles to them, and also to recognize their achievement. So I think this is important, and also we should do more community engagement with the youth, especially to give them internship opportunity, or having a field trip for them, for example, visit to Hong Kong Legal Week, and also to other nations, so we can learn about culture, art, and also to preserve the legal system in each country for the greater benefit of the mankind. So I think this is important, and also we need to ensure fair and equitable access for all citizens by having a efficient system of legal aid system, so that all people can have access to justice, and also they know their right by having educational series and also talk show like this, and also seminar. And yeah, we invite panel to talk about what is the basic human right, fundamental human right as per international treaties, and also in their own constitution, for example, like freedom of speech, freedom of religion, freedom of assembly. So I think this is important. That's why I'm a strong proponent and advocate for human rights, and also to equal rights between all humans. So I think this is important, and also I push for more youth empowerment and more significant role to be given to the youth in administration, and also in government, nation building, and also private sector, so that youth can voice out their opinion to ensure that the policy drafted is inclusive, holistic, and comprehensive, and also in line with Malaysia, in which we have amended the constitution to ensure that the youth of 18 years old can vote now next year. So I think this is really important, that the youth can bring in their voices to the parliament and the state assembly. So hopefully we can call for more collaboration to realize SDG, to ensure that we can build a strong nation together, and also a peaceful world for all to live and thrive.
Thank you, Sashin. Sashin also mentioned about environment and human rights issues. These are also important SDG goals. I understand that Jeffrey and Joanna, you've been volunteering in NGOs in related human rights and environmental agency. Can you share with us a bit more on your work, and how do you think that could contribute to the SDGs?
Well, I think we equally work, have experience in NGO and like societies that focuses on human rights and also environmental aspects. But I think I'll go first. Well, we're both from Borneo states of Malaysia, which is Sabah and Sarawak, which is, if you don't know, it's one of the most environmentally diverse places in the world. And even in my first year of law school, I have a lecturer who encouraged me to join a internship program or a internship opportunity with a local environmental law group. And through that experience, I was able to understand that the work of law is far beyond what we know as corporate or criminal, that there are a lot of public interest litigation, and there's a lot of work to be done in the ground. And especially for me, we work with villages who are bringing cases against the government for maybe land encroachment, or like the building of government buildings without the permission of the traditional landowners. And this sparks an interest in me to understand more about how, lawyers or young lawyers or law students could do not just, glossy corporate work, but also go to the ground to actually understand what are the realities of our people, our citizens. I think my colleague Joanna has something to share too.
Okay, so my love for nature actually sparks my passion in environmental law. So in in our faculty, we have ecology, which strives to expose to the youth on the laws that we have on environmental laws. Because being part of Malaysian myself, I can say that there are people, not only youths, that are not aware of the environmental laws that we have. So what we do is we write articles, we host events or webinars to expose to the people. So this is what we are facing in Malaysia and how should we solve it. So we would invite senior lecturers or experts who have knowledge on environmental law and just expose the youth on what we can do to bring a change to the world. But my experience in fighting for human rights actually sparks from moot competitions on freedom of expression and freedom of religion. So my involvement in the NGO, which we call Hakam Youth, actually strives to teach the youth in Malaysia how would you fight for human rights and what you can or shouldn't do. Because in the federal constitution that we have, Of course, freedom of religion or freedom of expression is provided in the federal constitution, but most people don't know the extension to which we can express our thoughts or expression. So to them, it's more of like, oh, we have freedom of expression, so we can say whatever we want, but they don't know that it comes with limitations. So being part of that NGO, we actually get to educate people and expose to them the issues that we have here in Malaysia and what the law says about it. So that's part of what Geoffrey and I are doing. Thank you very much.
Thank you, Jeffrey and Joanna. It's very important that, in terms of law and freedom of speech and freedom of expression, there's limitations, and that's important that there's education and capacity building for young lawyers, soon to be. And if I were to ask all of you to say what do you think is most important as we move forward to the future? What is the most important area that you think for the development of rule of law, if you want to advance further?
Thank you, Venus. I mean, the students mentioned the environmental, climate change, sustainability, and of course, the COP26, the UN Climate Change Summit has just been held in Glasgow, in Scotland. And as lawyers, we have a lot to follow up if they do come up with the international type of treaties. So how to rectify those treaties into local laws, how to implement those local laws into legal terms, and how do we as normal citizens practice those agreements is important. So that's number one. Number two, we talk about human rights. Can I just remind the international audience that in the basic law, actually the International Covenant on Civil and Political Rights are protected expressly in our constitutional document. So it's entrenched in Hong Kong in terms of protection of human rights. Thank you.
Thank you, CM. So we've got environment issues and human rights issues. So Alex, which area would think is most important?
I would say we are facing some challenge across the world. Similar points raised by CM about the obligations of respective country under the international treaties or conventions. As we see in recent years, some countries, for example, climate change, they chose to opt out from the international treaties or protocol. And after all, we understand all those international obligations under the treaties. Of course, they are legally binding, but after all, that we lack efficient or effective mechanism to resolve those disputes when one or more parties, they intentionally choose to ignore their obligations under the international treaties, unlike what we have in the domestic system. So after all, the worldwide respect to the international treaties, obligations, they need to feel bound by those duties. And this is very crucial to uphold rule of law in an international aspect.
Thank you, Alex. Stephen and Glenda? A short sharing of what do you think is most important area of law for advancing the rule of law?
Perhaps I'll go first. I think actually it all starts with good legal education. I mean, of course, you don't have lawyers unless you have law schools, and you can't have, good law schools if you don't have good law teachers. So I think ultimately it comes with making sure that legal education is accessible, not just in terms of like at a professional level where you're training, young people to become lawyers and to fulfill, different legal positions, but also just in terms of general legal awareness. So, there's a lot of people who don't know their basic legal rights. And there are a lot of, issues that to do with law that people aren't aware of, only for the fact that that information isn't provided to them. So I think in terms of what's most important for advancing the rule of law, if we can make legal information, education, and just access to general information about the law more accessible, then I think that would really help advance the rule of law and lay a really solid foundation for a really solid legal system.
Thank you, Stephen. Glenda, in the interest of time, we have to make it quick.
Yeah, I completely agree. Actually, this is what our people was talk about. So essentially, it was about access to justice and pro bono work, right? And I think that's a very important pillar in terms of advancing the rule of law and saying for any country in this world. Yeah, thank you.
Thank you, Jeffrey and Joanna.
Well, I completely agree with what Zafan said. Legal education, legal awareness is really important. Ignorance is a bliss. Everyone can ignore things, but at the same time, legal awareness is really important. And I'm really proud that our young generation is getting more and more aware of our legal rights, our duties, but at the same time, we must make informed decisions also. And I think that's really important.
And Joanna?
Sorry. Yeah, I also have to agree with Zepan. Coming from Sarawak myself, we aren't really in touch with legal awareness over in Sarawak. So usually they would come to law students and ask for advices, and it's obvious that they are not aware of their basic rights. So legal education is to access to justice. Yes.
So last but not least, Sashen, do you agree is also legal education?
Yeah, I agree, and also I agree that marching toward the future, which we witness that the world is developed by leaps and bounds of the digital world, we also need to strike a balance between free speech and also personal privacy and data protection. And second is to ensure that the human are educated enough to know about the fundamental human rights, legal system, and the act of parliament. For example, like national legislation and also international treaties. And last but not least, the judiciary and the lawyers should make sure that legal certainty exists in the court system, and also the judiciary should deliver the judgment based on laws and facts to set a good precedent. And as said by the panel, all the lawyers actually are the officer of the court and the servant of the nation. So we all have a greater duty to the court and the nation by contributing to the development of rule of law and serving justice. So with that, thank you so much.
Thank you. Thank you for joining us in this 1 hour transformative journey. There's a lot of work to be done. We've heard from CM, Alex, Stephen and Glenda, Jeffrey and Joanna and Shangxian, from legal education to human rights issues to environmental issues. And that all leads to how culture and legal tradition comes into play with the rule of law. But as the Chinese saying goes, 千里之行始于足下. The journey 1,000 miles starts with the first step. And we hope you'll continue to support and join us in our department's Vision 2030 for Rule of Law. A big round of applause for our panelists. Thank you.
Thank you very much for the insightful discussion. Please stay with us for a quick virtual photo. So to our online speakers, please look at your own camera. And for our on-site speakers and moderator, please look at our camera at the very back. So on my count of 3, 3, 2, 1, smile. One more. Keep smiling. All right, so let's give our speakers and moderator a round of applause. Thank you very much. So before we close this session, it is my pleasure to invite Professor Dr. Shirakiat Sathirathai to deliver the closing remarks. Professor Doctor, please.
Thank you very much indeed, Secretary Teresa Cheng, Secretary of Justice, Excellencies, ladies and gentlemen. First of all, I would like to commend Secretary Teresa Cheng for her initiative to establish this task force on Vision 2030 for the rule of law, and for initiating the Hong Kong Legal Week, initiating the International Youth Forum, the Rule of Law Signature Engagement Event, a journey of transformation for a sustainable future. It is indeed a great contribution to raise the awareness of the rule of law in Asia. I sat for the whole session, the previous session, and I really appreciated that panelists and everyone who joined on the panel value the international exchanges and value the diversity. I just would like to offer some food for thought for this session. It is indeed important to engage youth and we should continue to provide forum to have their voices heard and their views heeded. In intergenerational convergence of views on the need for the rule of law is essential for peace and sustainable development. Rule of law can be strengthened by building strength out of diversity. Asia is so diversified, so do other regions of the world. One-size-fits-all approach cannot strengthen the rule of law. Understanding different cultures is key to the success of the implementation of the rule of law. One example I always like to refer to is how the late King of Thailand helped enforcing the rule of law with the interplay between culture, social dimension, and the law. Decades ago, the late King of Thailand spent years in working with Hill tribes people to convince them to stop growing opium poppy. In the past, Thailand used to enforce the law against narcotics by sending soldiers to cut down opium poppy. The result was Hill tribes people became communist insurgents. But when the late king initiated his crop substitution project, understanding the reason why they grew opium poppy, and found out that they used it for anesthesia and generated small income, it was the middle person who came out to benefit, especially financial benefit, not the opium growers. So the king told them that he would apply other medicine to cure, to reduce pain instead of opium. The Hill tribes agreed to try. The king also asked them if they would try other crops to generate income. They agreed. That's how eradication of opium poppy field and crop substitution project has started. With such approach, Hill tribes people have themselves become law abider and at the same time, law enforcer. They have stopped growing opium poppy and can earn their living by growing temperate plants and earning sufficient income by selling flowers, fruit, and vegetable until at present. Of course, it's taken years before the project will be successful. This brief example shows differences between rule of law and rule by law. It shows the need to blend Hill tribes' way of life or living culture with the law. Then we can initiate new approach to involve them to be a part of the solution, not a part of the problem. Enforcing the law without understanding the sensitivity of culture and reality on the ground may lead to injustice. As the saying goes, summa jus, summa injuria, or extreme justice is extreme injustice. Of course, the example above cannot be generalized either, but it demonstrates that there's a clear and important relationship between culture and the rule of law. The question is how the younger generation and future generation can adapt this relationship of culture and the rule of law to be applied to different situations where one-size-fits-all approach cannot be applied. Applying culture to the rule of law does not mean that we can bypass the law and its enforcement. It means that we must find a way to apply and enforce the law where peace and harmony can take root in a society. Law enforcement and peace must stand side by side in every society. If we enforce the law strictly without due consideration to the negative social impact, peace and development cannot exist. Sustainable development goals cannot be achieved. It is therefore the art of management to blend rule by law with rule of law, where law is respected, where law is upheld and can be enforced with the willingness and understanding of the people in the society. This is how development with rule of law as a foundation can be sustained. This is how culture of law enforcement can be cultivated and sustained. Ladies and gentlemen, while a journey of transformation for a sustainable future, not ignore the relationship between culture and the rule of law. Technology, especially social media, can both promote and jeopardize the existence of the rule of law. As social media has shaped perception and knowledge of people from different generations, we need to work together to ensure that people of different generations can engage in deliberative dialogue. People, the youth or not the youth, must be aware that different views do not mean that we cannot live or work together. Difference does not mean division. We can agree to disagree and try to listen to different views, since, as I said earlier, we have to build strength out of diversity. Having said that, such diversity must be based on fact, not fabrication or distortion of fact. Here is where the big data technology can play a role to separate fact from falsified fact, to separate emotion from reality. I therefore commend Department of Justice establishment of legal database and China's emphasis on big data for sustainable development goals for proper observation of the rule. In conclusion, it is a major task for all of us to raise awareness of the relationship between the culture and the rule of law and build legal and political environment where such relationship can be implemented. It is also a major task for all of us to create safe space where different views and opinions can be expressed and exchanged with an aim to lead to diversity, not division. And finally, while technology helps society to leapfrog to better life and economic productivity, technology itself can create distortion and fabrication of facts, leading to political division. Here is where, again, big data for rule of law and sustainable development goals come into play, where deliberative dialogue mechanism must be available for people of different opinions to exchange views and verify facts. Big data technology can also help to create a verification process of facts so that the dialogue and consultation process will not be misled by falsified information, leading to misunderstanding, which undermines culture of law enforcement and the rule of law. It is the rule of law, and I stress again, which is the most important element for achieving sustainable development goals. Thank you very much for your attention.
Thank you, Professor Dr. Sathir Thai. So we have come to the end of the morning session and it's time for a break. Please return to the hall by 2:10 for the afternoon session. And for our online participants, please log in again by 2:10. See you after the break. Thank you.